Okay, in the interest of time, I'm going to start talking, and you'll need to start listening. Okay, thank you. So we're going to be talking about global perspectives on AI regulations and copyright. I'm John Degen. I am the CEO of the Writers Union of Canada and the chair here at IAF. Beside me is Arnaud Robert, president of SOFIA, our hosts. Thank you very much. Anthi Akritidou, Head of Legal and EU Affairs at IFRRO, and Christian Zimmermann, CEO at DACS. So we'll all be speaking about perspectives on AI from our own sort of national and professional perspectives. I'm going to very briefly give the Canadian AI story because, as I just told the panel, our country has done basically zero on it. So there's not a whole lot to report, but I will let you know what we have done. So there's been a great deal of talking about it in Canada, very little to no activity. The cultural sector industries in Canada have been officially consulted by our government through online surveys and requests for submissions several times in the past 2 years. Several times I have answered the exact same questions for the exact same departments of our government, so I'm not quite sure why they need the same answer over and over again. For the most part, we find the questions come to us from a very disturbing perspective, the perspective of that AI's complete integration into our work is a given, and that all that is left is to discuss just how much permission the government will inevitably give to AI developers to use our work without permission. A question that comes up in the surveys all the time, please explain to us what a new copyright exception for AI developers should look like. Of course, we respond that such an exception should look non-existent, but this seems not to penetrate because the inevitable next consultation comes along and it comes from the same direction. We've recently even discovered a Government of Canada blog posting on one of their official sites, sadly from our own ministry, the Department of Canadian Heritage, the ministry I deal with the most, explaining to writers all the exciting ways that we might use AI in our creative work. And we were never consulted on this sort of PR campaign that our government is running for the AI industry. So much of our work right now is grabbing onto a runaway cart and pulling back as hard as we possibly can. At the Writers Union of Canada, we spent a number of months last year studying the possibility of a class action lawsuit against AI developers similar to what's going on in the United States here and there, but adding the element of moral rights. We just heard about moral rights on the other panel. Canada has a moral rights regime that the United States does not have, and so moral rights is not part of any of the existing legal challenges in the United States. We thought perhaps we could add that element and strengthen everybody's argument. But after about 6 months of research, our legal team came back and said, Canada is not ready to protect your moral rights in this way, is our conclusion. So the risk would be too great to your small organization in terms of just the amount of work that you'd have to put into it, the amount of finance that you would have to put into it, and quite possibly it would go all the way to the Supreme Court, which takes about 10 years in Canada, and you might inevitably lose, and that would just be a waste of time and the strengthening of the other side. So instead, we are supporting the Authors Guild in the United States as much as we can, and I think Umar is at the back there. Yes, he is. And we're just waiting for him to tell us what to do, and we'll do it. We'll help in whatever way we can. As well, the thing I'd like to say about this topic is that I don't think we as a sector of professional organizations have quite accepted the emotionality of the arguments that are going on out there. HarperCollins came up with a negotiated license deal with an unnamed AI firm for $5,000 per book, split evenly between author and publisher. And when that deal came out, I had a lot of phone calls, a lot of emails to my desk saying, I'm a HarperCollins author, I'm a member of the union, should I sign, should I not sign, how do you feel about this? So we had to really dig in and figure out what was going on. And so we put out a statement, and our conclusion was, A, the money is not enough. $5,000 per book is not enough. The license split between author and publisher is completely unfair. There's no good reason not to name the AI company, and it's a little hinky that they're not naming the AI company. I realize we all know that it's Microsoft now, but originally they were not naming it. But, our statement said, but at least the existence of such a license indicates a nascent licensing market exists in the AI space and should be protected by regulation and legislation. This all sounded really good to my board. It sounded really good from the staff perspective of having studied the issue extensively, but boy, did our members hate it, except the members who were HarperCollins authors and who were accepting the deal. We were accused on social media of selling out writers to the robots and not holding up the solidarity that we normally would. Of course, others loved the deal, even non-HarperCollins authors. There's a lot of authors in our organization who are experimenting with AI, and they have a completely different perspective. But the point I'm making is that these arguments are emotional, and they're at that level still. And while we can talk about it in a very abstract, professional, business-like way, I think our members are not there yet, which is fine. And I think maybe we want to back up a little bit and find our members where they are and help bring them along to discussions like this. And finally, I would just like to note that the famous fellow Geoffrey Hinton, who everyone is calling the godfather of AI, who famously has warned the world that AI could go out of control and take over and destroy humanity. Well, he's Canadian, and he lives very close to me in Northern Ontario, and so I apologize. And now I turn it over to our panel. So go ahead, Arnaud.
Thank you. I just must add that I'm SOFIA's chairman, but I'm also general counsel for Hachette Livre. So I'm the publisher in the room, but it's as you know, SOFIA is co-chaired by publishers and authors, and that's a very efficient way to do it in our common view. I would say that as to France, there has been no legislative initiative regarding AI in France, as it is the case in Canada. The only regulation, but that's one regulation, is the EU AI Act. I guess Anthi will talk about it, but we should bear in mind that this regulation is not about copyright. It's about protecting. I'm talking under the great authority of court here, but it's really a regulation about protecting citizens, protecting democracy, protecting individual rights, and it has an approach based on the risk borne by different types of AI, but it doesn't use the word copyright or maybe for one or two items, and the only interest that we find in the AI Act, which is a real interest, is the need for transparency and the obligation for AI actors to provide with a sufficiently detailed summary of copyrighted works that are used by AI. And there is a fierce fight, but I guess Anthi will tell us about it. There's a fierce fight in Brussels and in Strasbourg to define what is a sufficiently detailed summary of copyright works. So first comment, there is no regulation now that is dealing with AI relating to copyright, except the side effects of the EU AI Act. There is one regulation that is used, that is used by AI actors, for legally grounding the theft and the piracy of our contents is the 2019 copyright directive with the TDM exception. And we used it as well in France because all publishers, all major publishers have expressed the opt-out on their content and have sent letters to the digital distributors of their content to say that they wanted their contents, the global contents that they had been publishing to be opted out. Obviously, it's an information that is displayed to the AI robots. It doesn't prevent AI robots to crawl our contents, but it's a first step. So no regulation. So we feel that we will have to rely on case law at first. So we decided, and it's been filed yesterday, all the major publisher association at the SNE and the major authors organization in France decided to sue Meta, and it's been filed yesterday because we have proof that in the books, the book 3 dataset that Meta used for training its Llama language, we found that entire books, hundreds of entire books were reproduced. So we are going to trial against Meta because we have the proof, and it's not the case for other datasets. But we, as you may know, the book 3 dataset was open once upon a time. So we, and thanks to our Danish correspondents, we investigate into this dataset, and we found proofs that our works were copied. All the once again, hundreds of books by major French publishers were copied in this dataset, and we know that it's the same in the UK because there has been a public comments that the Harry Potter books were found in the Llama dataset also. So we think it's not only about French books. So we think that case law we probably will be the good. I think we hope the good leverage to have the very beginning of a discussion with AI actors, and because that will be my third comment. We have no regulation for now, but we also have no beginning of any kind of dialogue with AI actors, which seem to have been the case in the US with this agreement that you commented on between HarperCollins and Microsoft. So we are at this stage in France.
Thank you very much. And yeah, many Canadian books and books 3 as well, full titles. Anthi?
Thank you so much. Am I audible? Yeah? Okay. So good morning, everyone. And first of all, I would like to extend my sincere thanks to the International Authors Forum for the invitation. I'm very glad to be here and discuss with you about AI. What a surprise. I mean, this is not a very common topic lately, right? And my presentation will focus on what is going on at EU level right now. And I very much looking forward to having a discussion with all of you on our developments. So let me try with, okay. Magic. So on this slide, I have enlisted the topics I would like to touch upon today. I'm not gonna read the slide for you. I think, yeah, this is just a skeleton that could be useful. I will quickly go to the next one. Yeah. And I will start with the AI Act. And I'm pretty sure all colleagues from the EU are fed up with hearing about the AI Act. As mentioned before, indeed, it's not a copyright legislation. It is a product safety legislation. It is officially the first ever legal framework and it comes from the EU. We have a regulation whose number is 1689 from 2024. It entered into force last August 2024, and we are expecting it to start applying in August 2026. However, there are several exceptions to these rules. We have some provisions, or better say, blocks of provisions that will apply either earlier or even later. The AI Act has adopted a risk-based approach. We have 4 levels of risk. All AI systems consider a clear threat to the safety, livelihoods, and rights of people are completely banned. High-risk AI systems are subject to strict obligations before they can be put on the market. We have limited risk AI systems, which are subject to specific transparency obligations in order to ensure that humans are informed when necessary, so to foster transparency and trust. And minimal or no risk is not regulated by the AI Act. So now moving to some specifics of this regulation, which are relevant from a copyright perspective. Chapter 5, regulating general purpose AI models, will start applying already this year on the 2nd of August 2025. And Article 53, which falls under this chapter, includes 2 key requirements for the copyright sector, I would say. It requires the AI model providers to put in place a policy to respect union copyright law and related rights, and in particular, it says, to identify and comply with a reservation of rights expressed pursuant to Article 4, Paragraph 3 of the DSM Directive, so the TDM exception and the opt-out clause. And the second obligation, to draw up and make publicly available a sufficiently detailed summary about the content used for training of the general purpose AI model according to a template that will be provided by the AI office. Let's begin by unpacking these obligations. I will start with the first one, the policy to respect union copyright law. We have a recital 106 from the regulation. This appears to give the obligation an extraterritorial effect. And what do I mean by that? In simple terms, it doesn't matter where the AI model's training happens. What matters is that the AI model is placed on the EU market. The final model is placed on the EU market. And this means that companies, regardless of where they operate for the training phase, will need to comply with the EU law if they plan to offer their systems, their models in Europe, actually within the EU. Another conclusion we reach is that both from the main provisions text, and we saw it before, and also from other recitals that accompany this, recitals 104 to 106, the EU legislator has connected the TDM exception to the AI training. So we all know that this is a highly controversial issue. However, the European Commission has adopted a very clear approach towards this. The Commission says that the TDM exception is highly relevant for the AI training, and it emphasizes that now it is the time to make this work, to make the exception be applicable in practice. This obligation on the copyright policy is intended to be further specified through the code of practice that I'm going to talk about later. So this is what we are trying to do in these discussions. So now concerning the detailed summary, we have recital 107 that gives some more clarity regarding what this summary should include. The purpose is to enhance transparency around the data used in both pre-training, but also the training of general purpose AI models, especially when it comes to content protected by copyright. What should the summary include? So first of all, it is stated that the summary should take into account the need to protect trade secrets and confidential business information. It doesn't have to be technically detailed, but comprehensive in scope. The summary should list the main data collections or data sets that were used, such as large public or private data sets or data archives. Additionally, it should provide a narrative explanation of other data sources, helping stakeholders understand the model's training process. The aim of the summary is to allow everyone that has a legitimate interest, so mainly authors, publishers, and other rights holders, to understand what data has been used during the training phase in order to enforce their rights under the EU law. We will dive deeper into what the AI office has done so far in this direction. But before this, just a quick introduction to the AI office, which was established by the AI Act. It was formally launched in June last year, and its role is to implement the regulation, particularly when it comes to general purpose AI models. It comprises of 5 units. You can see them on the slide. And one of the key roles it has is to monitor the copyright-related transparency rules and to offer this template of the detailed summary that AI model providers must publish. The AI office is also closely monitoring the process for drawing up the first code of practice, and it will monitor the drafting of other codes of practice that will be produced under the AI Act and continue its oversight even after these codes are finalized in order to evaluate them. So a few words on the general purpose AI code of practice under the AI Act, which aims to clarify the rules for generative AI model providers. The process is still ongoing, and we are expecting it to be finished by the beginning of May, so just before the AI Act's provisions start to apply in August 2025. There are nearly 1,000 participants to this process, which is a very high number, of course, as you can imagine. The work is being done across 4 different working groups. IFRRO is part of working group 1, which focuses on transparency and copyright-related provisions. This is the only group that deals with these topics. As chairs of the group are Professor Alexander Peukert from Germany and Cécile Castel-Renard from France. So far, we have had 3 plenary sessions. We also had 3 meetings within working group number 1. And we have seen, well, today we have seen actually 3 draft code of practice. We have submitted comments to the first and the second draft. The third draft was only published yesterday, and the deadline is the 30th of March for comments. So there are 2 possible outcomes here. The first is that the European Commission may approve the code that will be signed by as many general purpose AI model providers as possible. And the second scenario is that the AI Act and the provisions on transparency could be implemented without the code. So in August 2025, the provisions will start applying, and the Commission might develop its own implementing act in the future. There have been several issues with the drafts, but also with the process, both operational and content-wise. I have included only a few in this slide. There is a lack of meaningful stakeholder engagement and transparency. We don't know exactly who participates. The names of the organizations have been made public, but we don't know which individuals are part of the process. We don't have any clue on this. We have very short time frames for comments. For example, when it comes to a draft of over 40 pages, we have been given 10 working days, and for membership organization, this is impossible in order to coordinate and collect input to further inform our response, for example, at IFRRO. And we have also seen that the comments have not been taken into consideration. Once we submit our comments, the first draft, for example, I remember that the second draft came only after 2 weeks, and you have 1,000 participants. I mean, it is not really possible to assess all these comments within 2 weeks. Now, on the draft template for the summary that was mentioned before, during the meeting of the 17th of January of the working group number 1, the AI office presented a draft template, which included 3 key questions for the stakeholders, and we were called to answer to these. So it divided the questions into 3 sections: general information, disclosure of information on data sources, and data processing aspects. These were the questions that we were called to respond to. The deadline was the 31st of January. I will be super short. IFRRO provided its input, of course, and we asked for further granularity and transparency on the details to be provided for the rights holders in order to be able to exercise the rights. We should bear in mind that this document may be the primary, if not the sole one, by which rights holders can assess whether the content of theirs has been used or not. We asked for full disclosure of data sources, on data processing and rights protection, and need for further clarity when it comes to definitions and processes. I will now move to the Council of the EU. So we saw in December that the former Hungarian presidency of the Council published a summary of the members' contributions to a policy questionnaire it had raised on the relationship between Gen AI and copyright. And I think we have some very interesting points coming from the member states. I have included some. The document is quite long, and I would highly recommend you to read it if you have the time. So the main points: current EU legal framework is sufficient to address arising issues. More clarity and certainty would be required for a better implementation of the existing EU acquis. The applicability of text and data mining exception and its opt-out mechanism for the AI training process raises certain unclarities, and there is a view from the majority of member states that copyright uses for AI training go beyond the scope of the TDM exception. Diverse views on setting up an EU-wide database in order to provide more legal certainty within the EU regarding the functioning of the opt-out systems. Works may be eligible for copyright protection only if the human input in their creative process was significant and all the prerequisites for copyright protection were fulfilled. No need to provide any kind of new or additional copyright-related protection, including a new sui generis right, for example, to AI-generated content. In the case of AI-assisted works, the general copyright rules should be applicable. And a significant number of member states recognize that AI raises practical challenges for individual rights holders, making collective management essential. Individual licensing was also highlighted as a very important factor. In January this year, the Polish presidency of the Council, we have a rotating presidency every 6 months in the Council. So the new presidency, the Polish presidency, distributed a questionnaire on the current and future challenges to the collective management organizations ecosystem in the EU. So member states have been called to provide responses. A part of it is dedicated to AI. There are some key elements that the paper acknowledges, but I will not stand here. I want to show you the questions that the paper has raised for the collective management organizations. So the presidency put together this list, as you can see on the slide, and asked whether CMOs use AI for blockchain or blockchain technologies to identify AI-generated content, if they have mechanisms to determine whether works submitted by rights holders are AI-generated, Additionally, CMOs were inquired about challenges in licensing content for AI training and so on. We have not seen any responses from the member states yet, but similar to what happened with the Hungarian presidency, we expect that we will see at least a summary of the responses that will be submitted. This is my second to last slide, but I thought it would be good to refer to what the EU IPO and the European Commission is doing on this field. So there is an ongoing EU IPO study on Gen AI and copyright implications, which is expected to be completed by the end of March. This study has a technical focus rather than a legal one. It aims to explore key aspects of AI and copyright. So it will focus both on the input side and the output side. On the input side, it will focus on the use of content, how content is used at different phases of the Gen AI system training, and so on. And on solutions and practices, it explores existing solutions that aim to limit, reserve, or support access to copyright-protected works for training purposes. From the AI output side, the focus is on the generation of content, and again, there will be some solutions and practices. It will also address some economic considerations, but this will not be the focus of the study. And this is my very last slide on the European Commission, which is preparing a study to assess the feasibility of a central registry for TDM solutions. So there will be a centralized, this is the purpose, first of all, to assess the feasibility, but let's be honest, I mean, when the European Commission gives a study to explore the feasibility, it is always a positive result. So the purpose is to set up a registry / database of opt-out solutions. This will track content identifiers, metadata in order to complement the already available mechanisms and standards. The launch of the study is expected before summer, so we will not see anything before the end of the year. This has been a bit long, but there have been a lot of things happening in Europe in the last some months, 2 years maybe. And yeah, I'm very happy to respond to any questions you might have. Thank you.
Thank you very much, Anthi. Are there any questions right away before we move to the next presentation? At the back, yes. We'll need the microphone over there. Serena's coming.
Thank you. Very interesting, detailed, thoughtful presentation and thorough analysis from both of you so far. I really appreciate it. It gives me a lot to think about. Listening to this, I sometimes feel like I'm driving down a highway through a rainstorm with a lot of fog, where people are supposed to put up road signs to tell me where I'm going. And I'm trying to get to a restaurant, and I don't know if I'm ever going to get there. And when I get there, I'm not really sure there's any food to eat, and the restaurant's open. So I have sort of the same question for both of you about the food at the restaurant. With respect to the SOFIA lawsuit against Meta, and with respect to the end results of these studies and the analysis of what's going on, with respect to each in the Meta context, what do you see as being the payout, the remuneration that might actually be received as a result of the legal precedent that you establish? Is this a precedent only, or does this return to authors money in their pocket, or just some future possibility for them to pursue it on their own? And with regard to the AI Act and the TDM exceptions, which to me, in my mind, are a complication of the implementation of the Act, as well as guidelines for maybe some sort of solution. I didn't see anything about remedies or dollars or euros. What are the penalties or hoped for consequences of establishing any of these laws Or do we wind up with something like in the United States where we have a copyright law that gives you rights, but there's no effective remedies if you want to pursue them?
Maybe I can answer. I just have to precise that the suit against the trial against Meta is carried out by the French Publisher Association and not by SOFIA. To be, otherwise Geoffroy is gonna fall on the floor. No, it's the French Publisher Association and the major French author association that joined to ask Meta to stop using the content. To be honest, it's the first. It's the for now we have difficulty to find. We found proofs of reproduction of our content, but we have no the goal of the trial is to have Meta stop the use of our content and have and get from the court the ability to conduct a more profound investigation into the data set to be able to articulate some kind of remedy. So for now, we are just asking for €1 damage money. But in the course of the trial, our goal is to articulate, is to ask the judge for more investigating means to be able to articulate some kind of amount. But honestly, the main goal is to have Meta stop the reproduction and the use of our contents, and honestly to have Meta enter into some kind of discussion with all the right holders in France and in other countries.
I just wanted to say that when it comes to the remuneration, what the European Commission says is that the TDM exception and the opt-out specifically is there to help to facilitate the rights holders retain control over their works. And you have this, so you can opt out and then you can give licenses for the AI model providers or other uses in order to proceed with the use of your works. The thing is that this directive that introduced the TDM exception was put in place in 2019. And since then, we haven't seen this actually being applicable. We have not seen, we didn't have all the specifications, how this machine-readable opt-out should take place, what is considered machine-readable. We have seen also case law lately from Germany, the Lion case, which was not very clear on a lot of things. But when it comes to machine readability, it said that any reservation that is put on a website in a plain human language, if I can use this term, should be considered machine readable. But there are a lot of AI model providers that do not accept this. So they say that we need metadata, standard, and so on. And I think in the UK, something similar happened in the sense that they tried, there was the consultation for this text and data mining exception, and the justification was to facilitate rights holders to regain the, control of their rights. However, we have not seen in the European Union being advanced, and we have not seen licenses, even from parties that have expressly and explicitly reserved their rights, to be able to give licenses. So the executive vice president of the commission as well said that licensing is going to be important, but we have not seen how this will proceed if we don't have clear rules on the TDM, first of all, if it applies, how it should be expressed, and so on. And for the penalties of the AI Act, yes, there are some penalties for the companies that violate the law, but we should bear in mind that these are connected to the turnover and might be high penalties, but the profit they gain in the meantime sometimes even exceed the penalties. So it worth, let's say, the purpose to go and violate the law and then come and pay something less as a penalty.
Okay, I think in the interest of time, we'll go to Christian, and then if there are other questions, well,
Yes,
have them afterwards.
thank you. I can keep that very brief because Anthi basically just gave you the summary of what happened in the UK. So just very briefly, for those of you who don't know, DACS is a collecting society for the visual arts, and apart from collecting royalties and paying the royalties to artists, we also advocate for artists' rights. And just a little bit higher, or not, very quickly. These were our collections from last year, and as you can see from this slide, picking up on the previous panel, the artist resale right is very successful. So if visual creators can in any shape or form help writers with regards to the resale right on books, then more than happy to help. Just as an aside, whilst you were talking about the retailing of secondhand books, one of our members, David Shrigley, I don't know if you've heard that, but he actually jumped on this, and there is apparently a book by Dan Brown called The Da Vinci Code, which even charity shops went to newspapers and had articles in newspapers to say, please do not donate any more of these books to us because we can't shift them. And he actually collected 6,000 of them and pulped the fiction and reprinted on the paper resulting of it George Orwell's 1984 and sold them as a first sale. So you see, maybe artists can help with that problem in a variety of different ways. But coming now to the AI and the UK, like in every other country, we don't have any law yet. We don't have any judgments yet on the use of AI. And the EU AI Act does not apply in the UK because of Brexit. What does also not apply in the UK is Article 4, the TDM. So the only thing that the UK Copyright Act has is a TDM exception for non-commercial research. We had in 2021 our first consultation on a wider TDM exception to be introduced into UK law, which met with a lot of resistance from the industry because it was set or planned to be non-commercial, so there was no remuneration and it shouldn't have been limited in any shape or form. This got kind of withdrawn because of this huge outcry from the copyright industry. And then we had a government change from the Conservatives to Labour. And the Labour Party picked this conversation up with a new consultation. And the voice or the tone of the consultation was a lot more creator friendly. So it did acknowledge that there is something like the creative industries, which are also worth saving and supporting because they do contribute quite a lot to UK GDP, basically 126 billion a year. And so it should not be sacrificed in the light of a potential for growth through AI. And that consultation was launched in December 2024. What wasn't so good about it is that although it had very positive voices or noises about the creative industry, in January, we had our Prime Minister come out and give a long speech about how he sees that AI is going to be the cornerstone of any growth of the economy of the UK. So it's kind of a foregone conclusion. And the consultation didn't only touch on, or didn't only deal with AI itself, it had 47 questions. It also talked about technical standards for both opt-out and transparency, but it also tackled a very specific piece of UK law about computer-generated work. So we have a provision in our law that says that the author of a computer-generated work is the person who made the arrangements for its creation. There is kind of a debate if that can be used for AI-generated works and if there can actually then therefore be a copyright in AI-generated works. The US Copyright Office has said originally that there can't be. They now also kind of amended that slightly. Maybe Janet can highlight that more, that the parts that are human created can actually get copyright protection. we basically said that this provision in the UK Copyright Act cannot apply to AI because our Copyright Act is from 1988, and who on earth thought about this kind of current situation in 1988? Only to be disproven by reading through the accompanying documentation of how the law was created, when the people at the time actually did really discuss that this could cover AI. Not saying that this is going to be was the same kind of thing that we have today, but it does mention artificial intelligence. So we're currently having this as part of the consultation as well, how this should be interpreted and if this should be maintained as a provision in the law. Sorry, the NASS it sometimes works, sometimes doesn't. I'm doing it, okay? Great. Perfect. So the copyright consultation included 4 different options. One, the standard one, do nothing. The second one, strengthen copyright, requiring licensing in all cases, or a broad data mining exception, or number 3, which is probably the most like the EU AI Act or the EU developments, TDM exception that allows for a rights reservation. We kind of learned, at least officially, that opt-out doesn't sound very nice, so they kind of opted for rights reservation, which is an opt-out. And they said that that should be underpinned by supporting measures like transparency. And in the consultation itself, it was very clear that the UK government favored option 3. So the whole industry basically tried to argue against option 3, and we have learned from the past that we have to create a lot of evidence in order to substantiate our submissions. And so we at DACS tried to highlight that option 3 will not meet the policy objectives, as so far we have not had any, as Anthi said, evidence that any opt-out systems work where they are in place. So we basically favored option 1, but that can also only work when an option 1 is licensing, but that can also only work if there's transparency. So you do need to know what actually has been used by these AI companies or is being used in order to then be able to license. And any technical measures must also work for images, which could be standalone and incorporated in any other copyright work, like films or books. And we do believe or have kind of tried to argue that there should be fair remuneration, obviously, for the use of our members' works. We know, and I had a meeting with the Secretary of State on Monday, that they have received 11,500 submissions to this consultations, and that will approximately take them 6 to 8 months to go through them all, which is very surprising that in the EU they managed to kind of come up with a solution after 2 weeks, in particular because our government has said that they will not use AI to help with the sifting through the consultations. Very reassuring. That our work isn't being used to train AI systems. With regards to the evidence, and I think that's probably what everybody in this room in their countries have done, and I know LCS have done this as well quite extensively. We've surveyed our members to get the views from our membership to actually what they would want. We had 1,000 artists respond, which is dwarfed by ALCS's 13,000. Not sure how they did that, probably with AI. And then we've published a report on this as well, which you can see on our website. Just a couple of figures from this. Obviously, like you will know from your countries, artists are generally concerned about it. They want to be consulted, they want to be compensated, and they want to be able to consent to it and credit it. But we also had quite positive noises. So artists do believe in collective licensing. 84%, that isn't on this slide, have actually said they would support DACS to create a collective license to get remunerated and recognized when their works is being used by AI. In order to substantiate our submission as well, we've had a workshop, a cross-sector workshop with representatives from museums, from auction houses, from visual artists were included, and technical experts and representatives from the Open Data Institute, and we basically tried to establish what opt-out or transparency could look like. There is a report that we've published just in February, so you can access this on our website. But the report details the findings on what opt-out provisions would need to look like, what kind of interface, design, a website or application should have to allow an artist to opt out, similar to cookie banners for data privacy, what details AI developers should provide when being transparent about the use, how individual and small-sized creatives will deal with the administration of opt-outs and transparency, and how organizations such as DACS or other collecting societies can play a role in engaging with AI companies on transparency measures to produce licensing revenue. Because like we have heard before, we had no contact from any AI company to ask for permission to use our members' works. And that's kind of where the proposal in the UK consultation goes a little bit awry, because my personal view of that is that it is very odd to say that you should opt out in order to license, because isn't that exactly what we currently have with the exclusivity of copyright, that they should ask for permission before they use our members' works. The report also then comes up with a solution or a recommendation with regards to what transparency measures should look like. They should be legible, auditable, and impactful, as you can see on the slide, which I'm also happy to share afterwards. And just briefly also on the publicity PR side. So DACS joined the Creative Rights in AI Coalition, and we've managed to get quite a lot of traction. So we had this campaign slogan published on the same day in all of the main UK newspapers. That's literally apparently the only time this happened since the death of Princess Di, where every newspaper had the same headline. So we managed to get that out there. You may have also seen the BBC interview with Paul McCartney. So we do try to get some big names behind it, and to create some traction in order to get the public to get behind the conversation, really. And then just to show a couple of other points where we are currently involved. So we're trying to get an amendment through the Houses of Parliament to the data bill to talk about transparency. The coalition comprises 60 organizations from the creative industry. The Make It Fair campaign you just seen the picture of. And then, for example, the music industry in the UK, they just kind of published they did publish a silent album, which includes AI generated or non-AI generated works. And yeah, as I said before, the government said they received more than 11,000 submissions. So just very on the last slide here, our recommendations was that we would oppose to this notion of text and data mining being the solution to everything, that there should be a promotion of licensing, that the growth really of the economy can only be hand in hand, where the creative industries work with the tech industry, and the government should not really pitch those two sectors of the economy against each other. And if anything, there should be a strengthening of the copyright framework to encourage licenses and clarity and fairness, and that AI developers really should be playing the game and disclose their data sources, access details, and permissions. And that's the end of my slides.
Thank you very much, Christian. We have 5 minutes to a coffee break. Janet has her hand up. Can we get the microphone? I can only tell it's Janet because of your hair.
Clothes
I
in
can't
the
see 'em.
slide, I assume. Christian, that was a great report, and I'm basically, you called me out, so I'm going to give you the answer about United States with regard to AI-created works. There was a second part 2 of the Copyright Office's study on artificial intelligence just released at the end of January. So previously, they had just said no AI-created work could be copyrighted, and they've since sort of revised that by stating essentially that humans, if there's a sufficient or significant human involvement with AI-created tools, then the artwork can be copyrightable. Obviously, there's going to be a lot of case study that goes with that over the years if there are questions about how humanly created certain works were. But with regards to all of your points, Christian, about how the UK is handling AI, we couldn't agree with you more. We don't have text and data mining exceptions in the US. We have fair use. We're considering a variety of different ways to address that fair use, whether that be lawsuits or other matters. But the goal is to actively get our AI developers to agree to a market solution, which would be a licensing solution for our member artist works. And I represent visual artists in the US.
There's a hand right at the back. Yeah.
Hello, I'm Cécile Denier, speaking for Seattle Literary Translators. I would like very much to thank Anthi for putting up with the daily grind of dealing with a flowed process of implementing a flowed implementation of a flowed AI Act. I think the law is flawed in itself because it's a risk assessment law, but it spectacularly underestimates the risk of not strongly protecting copyright. And then the process is flowed, as you mentioned, and predictably the implementation will be flowed because I understand discussions are really going in the wrong way regarding the concrete measures to be put in place. So my question is, stepping back from that and thinking in terms of strategy and perspective, it's only fair that we put forward our concerns as creators, that we want our rights to be respected, moral, and perhaps get remuneration sometimes ahead, even if it's not a priority today. But I think in a negotiation, you need to take into account the other's perspective. And I think we are faced with an industry and authorities, European authorities, who are fearing missing the right boat, AI boat. And, but I think there's a case to be made today for predictability, rule of law, trustworthiness, factuality, and respect for copyright as potential assets for future I always mix them up, actors. So I'd like to know how you think we could make that case, to make them see and the authorities that this could actually be the worth of a European ecosystem and UK and Canada. I mean, I don't think it's a safe bet to try and participate in the current rat race where everything is up for grabs. And so we should play that card collectively. So again, I think it's Arnaud who said we don't have a dialogue with AI actors now. Dialogue is difficult with the European authorities, but still, what avenue do you think we could pursue?
Thank you. Thank you for the question. So we'll start with the AI code of practice to set some specific actions that we have followed internally at IFRRO. What we always ask our members to do is to provide us with input in order to ensure that we are all on the same page. IFRRO represents author and publisher organizations, but collective management organizations as well. So we have this beauty of representing different stakeholders in our field. And what we constantly ask them to do is to send us all the information, the views that they would like IFRRO's response to reflect on. Internally, we have also a lot of coordination calls to harmonize our action during the working group and the plenary session interventions. We exchange views on the problematic, which are a lot, points of the code of practice. This is very specified on this topic. But when it comes to the broader, let's say, reaction, we think that it is required for all of us to stand with one voice, because if we fragment our voices in different things, by someone saying something from the creative sector and the other one saying something different, we will not reach the result we want. So we are trying also at EU level to meet with policy and lawmakers, and we urge our members to meet with their national member of the European Parliament, so with their countries, their governments, with the copyright offices, intellectual property offices in their countries, in order to raise awareness about the problem. Because sometimes we see that there is a lack of information on what is the problem with the AI and how it can affect the authors, publishers, and other rights holders. So we always try to do this, to bring this as a topic in the discussions. We try through different ways to approach also the European Commission to communicate this message.
My point was to not only put forward how this is dangerous or detrimental to us, but to the wider ecosystem, even European society and European economy. I mean, we are faced with the danger of being of a data colonization, of European platforms demanding that they access for free to all of our data. This will prevent any strong European actor to emerge. So if that is their goal behind that, like we hear about Mistral, we need to show them that this is not the way, and not only for us personally, professionally.
I think the companies themselves know about the risk. The problem is that they do not put as a priority to deal with the creative sector right now, because we have a lot of our members that have offered licenses to the AI model providers to explain why this is required, and that this is actually the safest way, because exceptions and limitations are open to different interpretations and vague. So the licensing mechanism is the most secure way to move forward, and this has been explained. I'm afraid that it is not a priority for the big tech to move towards this direction. And Anita also mentioned yesterday that internally at IFRRO, we have put together a very useful instrument for our members, the AI Advocacy Toolkit, where we give some speaking points to our members to lobby with national authorities, European institutions, and so on, and bring forward not only the copyright aspect, but because this is a dynamic document and a living document that we try to keep updated all the time. The next step will probably be to focus on the AI safety in general. So not just the reproduction right that has been the first part, or the communication, the public right for the creative sector, but also to a broader theme, the AI safety.
Yeah, just one sentence and I'll leave the floor. You're making the case that this is the legally safest way, but as you say, I think you need to broaden the scope of the points you're making. I mean, this is the best, again, the trustworthiness, factuality, quality of the data they are using, and again, responsibility, sourcing, those are going to be major assets. You know, probably they don't care if it's safe or not. You know, the politics nowadays, you take it and then you see what happens. So, but for consumers, if their tool is going to have any value in the future, it lies within the terms I mentioned.
Okay, thank you. I'm going to encourage this conversation to continue during the coffee break. Yes. So thank you to our panel for great presentations and for the conversation. Thank you.